Tonight's webinar, which is presented by the Ross Parsons Centre for Commercial, Corporate and Taxation Law at Sydney Law School. This is part of our Law and Business Downtown, what we used to call a seminar series. This year, because of COVID, has become the webinar series. One of the great things has been that we've had quite a large attendance bump. I think particularly it's more convenient for people, but we're also getting a lot of people from interstate and even some people internationally. So that's fantastic to see. So welcome all. Thank you for giving up your time tonight. Tonight's topic is a continuation of our discussion around the position of boards and the duties of directors. You might recall that we ran a webinar a few weeks ago looking at the potential application for artificial intelligence in the boardroom. So tonight's topic, we're going to be focusing on the ever-expanding compliance obligations of Australia's company directors. And our presenters tonight are both partners at Gadens in the corporate team here in Sydney. So we'll have Matt Egerton-Warburton and Robert Tracy. So I'll throw over to you, Matt.
Thank you so much, Jason. And I should share my screen now. And Jason, do you mind confirming you can see my screen?
Yes, I can.
Great, okay. Well, thanks everyone. And thank you, Jason. So I'm a corporate partner at Gadens in the Sydney office. I've worked in New York and Hong Kong, and I'm actually licensed to practice in those jurisdictions. So I'm always interested in comparative law subjects, and this one raises some comparative law issues. Rob, do you want to introduce yourself briefly? And I'm a Sydney Uni alum, hence my tie. I think it's the third time I've worn it since my graduation in 1999. So very proud Sydney Uni alum. Rob.
Nice tie, Matt.
Thank you.
I'm Robert Tracy. I haven't, like Matt, worked in New York and Hong Kong. Rather, I've spent the vast bulk of my professional career in Sydney after a short start in Melbourne. If I was to put a tie on, it'd be firstly a Melbourne University tie, because it's where I came from originally, although I do have a degree from Sydney as well, so I could wear two ties if that's possible.
Great. And the way we're going to do it is that just think of Rob Tracy as my Roy to my HG, in that I'll be driving the lecture and Rob will be chipping in when he wants and when he needs, and when it needs a bit more colour, and hopefully he'll be anticipating questions from the audience when he does that. I've also asked Jason to also feel free to chip in if he has any questions and comments as we go through. So the idea is it's an informed discussion. So this is the topic that's been kicking around in my head for a while. It's a topic that directors talk about a lot in boardrooms in Australia through clenched teeth, and it's something that I think needs more public discussion and more public discourse. If people remember, there was an article in the AFR maybe about 2 weeks ago when I think it's Robert McFarlane or John McFarlane, who's the current chairman of ANZ, raised this topic yet again of the fact that being a director of a listed, regulated bank, the issues that directors on that board have to deal with are just far, far too great, too complicated for the board to do its job properly. And a few other directors around town have raised this issue, but company directors of banks don't get a lot of public support these days. But it's an issue that's worth considering. And I think we've reached a stage in our corporate governance development in Australia where our boards are actually not fit for purpose at the moment, but we'll get to that throughout the discussion. Robin, anything that you'd like to chip in on that in terms of just setting the scene for this talk?
No, I think you've set the scene well, Matt. And I think the issues that you're going to talk about and have raised are probably fairly widely thought about at the moment. So it's quite topical.
Right. So we're just going to do a quick roll through the historical development of company law or directors' duties in Australia, just to see where we've come from and where we've got to, and also where we're going. So I'll breeze through this quite quickly, but it's nice to have a look back and see where it all started. So of course, let's see if I can get this going. here we go. I like to talk about the tulip fields of Holland and the coffee houses of London where directors' duties started. And in fact, if you go back, the first cases are all to do with the South Sea bubble in 1719 and so forth. But that's where directors' duties developed. They developed in the law of agency, and also they developed out of the law of trust. And those are the two cores from where directors' duties have come from. But as the law developed and the common law developed, directors' duties had to leave that space, especially the law of trust space, because unlike a trustee whose job is to preserve capital, what we want our company directors to do is to take risks. And so a new body of law began to develop. And so we headed into the development of the common law around directors' duties. The business judgment rule was all part of that, providing a safe harbour for directors to take risks with shareholders' money, as long as it's for a proper purpose, taken with care. Then the directors had some protection. So heading into last century, and for most of last century, probably up until the mid 70s, early 80s, you had a pretty loose subjective standard for directors, whereas they're bound to act honestly, so you still had those fiduciary duties, but they weren't required to exercise any greater skill than what they had. So there was no standard of the reasonably competent company director. And this allowed these traditions of aristocratic Englishmen to be on the boards of some great global companies and not really knowing what was going on within the companies. In fact, Ford, in his first Principles of Common Law in 1974, made the comment that the duties imposed upon company directors were not very demanding, which is very interesting because that, of course, all began to change at around that time. So we head into the 80s, and I'm sure Jason Harris can talk about this much better than I can, but everyone realised that this standard was too loose, and we developed the objective duty of care for directors, such that they needed to exercise the duty of care that a reasonable person in a like position in the corporation would exercise. That was codified in common law in Australia in 92, with the business judgment rule being codified in 98. So this is where we get to with, our current directors' duties in Australia. So I'm pretty sure that most people on the call are across those, so I don't need to go into details. That's how we got to where we have got to today in terms of directors' duties. Having a think about where directors' duties are going in Australia, we can have a look overseas, and we're doing this more and more as everything globalized or has been globalized in the last 15, 20, 30 years. So it seems that a lot of trends in company law and regulatory development and so forth is globalizing and moving at a much more rapid rate. We see this in terms of the roundabouts of regulators. You'll often see someone who's a senior regulator in Hong Kong become a head of ASIC, or a former head of ASIC become a head of a regulator in the UK and Singapore, and as regulators move around and academics move around as well, everyone is becoming more and more aware of how other jurisdictions are doing things, especially within the common law jurisdictions. And so it's worthwhile having a look as into these other jurisdictions as to where we think Australian law will develop. And it seems like we're heading in the direction of the UK and Canada, where no longer do directors owe a duty to shareholders, no longer do directors owe duties solely to the company as a whole, but they're now beginning, to owe duties under the UK Companies Act, to the wider community and environment. So it's worthwhile just pausing and having a read of the UK Companies Act. It's called Enlightened Shareholder Value. So a director's duty is to promote the success of a company for the benefit of its members as a whole, with regard to a series of factors: employees, customers, suppliers, long-term consequences and impact of the wider community and environment. And in Canada, it says that directors may consider the interests of the corporation's various stakeholders. So we've moved beyond shareholders to, employees, creditors, consumers, governments, including in respect of the environment. So we're heading in a new direction in terms of directors' duties at the moment. I just thought it'd be worthwhile just to stop and have a look outside this civil law for a second. And Rob and Jason, maybe it's worthwhile pausing there to see if you guys have anything to add on the Australian position or how the law is developing in this space.
I'll just add a quick comment, mostly from your last slide there. I think it's really interesting that, say, the Canadian position, they've recently changed their law earlier this year, only at the federal level, though, in the Canada Business Corporations Act. And the provision, which is now in force, actually was introduced to try and codify what the Supreme Court of Canada has been doing over the last 15, 20 years in its decisions. Of course, in Australia, when we think about these sorts of issues, we have to go back to cases like Walker and Wimborne in the High Court, which is all the way back in, I think, 1978 or 1979. We haven't seen a similar push to actually change our legislation. And of course, if we go back to 2004 with the CAMAC review of corporate social responsibility, they specifically rejected the need to change the law because they said that the current provision that we have, which is to act in good faith in the best interest of the company and for a proper purpose, is already broad enough to take into account a variety of stakeholder interests. So it'll be interesting to see whether we have law reform here. I myself personally am sceptical that we'll see changes to the Corporations Act, and I would tend to agree that the cases that we've seen probably give enough flexibility to board members.
Jason, would it be fair to say that the Supreme Court in Canada that you mentioned is a bit more progressive on this sort of issue than our courts?
Yes, I would generally agree with that. They've had two very significant cases in the last 15 years that have looked at these issues, one from actually both of them involving creditor interests, but talking about the great flexibility that board members have in Canada. The business judgment rule, I would say, over there, which is very much a general law, not presumption, a general law presumption that the courts are not going to interfere in the commercial decision making as long as it's in good faith of company directors. But the statements in their courts over there very much have recognised that directors have the management prerogative and therefore the courts generally shouldn't intervene. Directors can take into account a variety of stakeholders in fulfilling that role. And it's not just about providing maximum economic return to shareholders. But of course, Canadian courts, even below the Supreme Court of Canada, going right back to the Tech Corp case, in the 1980s, recognising very strong management prerogative that really it is up to the board to determine what stakeholders' interests need to be taken into account and really how to balance the different stakeholders that are so important for the company's commercial success. So yeah, I'd say they probably are a little bit more flexible, a little bit broader, you might say a little bit more progressive than some Australian decisions. But of course, Tech Corp was applied in the Privy Council on appeal from the New South Wales Supreme Court in Howard Smith and Ampol back in the early 80s, late 70s. So, we have seen some of that flexibility here in Australia as well.
So I just thought it'd be nice to have a look across the channel, as we do in Australia, and not to New Zealand. There is a different corporate governance structure in some countries in Europe, basically, which started in Germany, where public companies have two boards, and this is something which I'm going to come to later in my discussion. But they have a management board, which is this that meets frequently, which basically runs the company, and then they have above that a supervisory board, which is meant to appoint, guide, and monitor management, and often, interestingly, has employee representation on those boards. Most of the directors on those boards are elected by shareholders. And so this is interesting because the issue that I'm going to raise is that as our boards in Australia become to get overwhelmed by the compliance burdens, this is a potential model for how you might fix it, in that you have a management board which has to deal with all the day-to-day compliance issues, but you have a supervisory board that can stand back and actually think strategically and think long-term about the direction of a company, which is a major complaint of our company directors in Australia, that they don't have time to do this at the moment. So, the pros and cons. Pros is that, you get more monitoring, and it's led to less aggressive performance targets. And, Germany has had very good labour management relations and productivity gains and so forth. So there's a lot of good things that come out of German corporate culture. The cons, of course, is that you've got two boards, so there's an efficiency and cost issue there. Rob, you mentioned that there's a UK public company that has trying out this structure.
Yeah, I've seen in practice a multinational but head office or headco listed in London, where they have in practice effectively a two-board structure where management deals with all the operational issues, and they do deal with all of the compliance issues. And so in practice, it works in the two-tier way that the German system works, but in practice, it doesn't relieve the top board of any of their responsibilities or duties. So while they've in the situation that I was talking about before, they have separated it. They've separated the practical role of dealing with it without relieving themselves of any responsibility. So they're halfway there in practice but still have the tension that all structures have under our current law.
Yeah, so I've talked about the development of directors' duties in Australia up to this point and where it's going and another thing. But there's, of course, another layering of obligations that are coming onto boards in Australia in a very big way that has popped up in the last sort of decade or so. Well, and there's actually two that I want to talk about. The first is statutory development. So, previously, directors' duties operated within the civil sphere, and governments really didn't get involved in breaches of directors' duties. And it was in 1958 the first time there were criminal sanctions for a breach of directors' duties in Australia. In Victoria, where the Attorney General could bring proceedings and levy fines of up to £500. Before that, there was kind of no public law around this, but this kind of opened the floodgates, and there are now about 700 legislative instruments which impose personal liability on directors: environmental law, workplace accidents, money laundering, non-payment of tax, ACCC privacy, etc. And it's as a body of law, it's really exploded in the last, in modern corporate governance history. So you've got the Australian statutory development, and then you've got the other sort of area where there's been a large growth in obligations has been in soft law. We talk about soft law, but this soft law is getting harder and harder and harder as we go through various editions of these laws. So when we think of soft law, we think of the ASIC regulatory guides, which I'll talk about in a bit more. We think of the ASX corporate governance principles for all the companies listed on the stock exchange. The first edition was in 2003. We're now up to the fourth edition. You've got, if you're, it used to be just banks, but it's all financial institutions are subject to APRA standards of governance for regulated institutions. They've got prudential standards that boards have to look for. ACSI is a very powerful lobby group of superannuation investors, and they have governance guidelines, which are mainly a set of ESG style issues that they want their companies in Australia to follow. And when you think about this group, at the moment, I think it's something like 30% of the ASX is owned by these large industry superannuation funds, and Deloitte predicts I think by 2038 that it's going to be 65% of the Australian Stock Exchange will be owned by superannuation. So this becomes a much more powerful lobby. It's already a powerful lobby, but it'll get more and more powerful. And then you've got the Financial Services Council, which is a group of financial services companies which have set their own standards, which are mandatory for members. So the reason I'm talking about this is just to give you a sense of the layering of obligations and responsibilities coming up to our major boards in Australia. So looking at the ASIC regulatory guides, corporate lawyers in Australia live and die, with these regulatory guides. There's now 265, and they're excellent guides to how ASIC view and interpret the law. But it's a lot of information: continuous disclosure, executive remuneration, how AGM should be run, shareholder engagement, all that type of thing. And then you've got the ASIC, the ASX corporate governance principles with the if not, why not, where there are 10 essential principles and 28 best practice recommendations, and each listed company in Australia have to respond to each of those principles and recommendations to describe how they are complying with them, and if not, why. So that's a significant burden for our listed companies. On top of that soft law, we're now seeing more and more ESG layering on top of it. So Section 299A 1C of the Corps Act requires companies to disclose material business risks affecting their future prospects. And ASIC considers material risks to include climate change and other environmental risks, which has really opened the door for ESG principles and boards having to respond to principles to do with environmental risk, labour practices, competition, supply chains, anti-corruption, and so forth. So significant new obligations are coming onto our boards in Australia. And I might just see if Jason and Rob have any comments on the soft law aspects of directors' duties.
So I might start just with a general comment, Matt. The thing that really stands out for me when you just list them all there summarising the main ones there in the slides, it's just the cumulative effect of all of this guidance, requirements. Are we getting to the stage where it simply is too complicated to do this job properly? Are we getting to the stage where we need to have things like artificial intelligence to be able to manage all of these requirements? It's not enough to just say, well, we'll get someone onto the board who's got some engineering experience or is a scientist or maybe has a legal background, accounting background. There's just layer upon layer upon layer of new obligations that regularly change. And it's almost like, this is just my own personal view, but it seems to me it's almost like we're playing a game of gotcha, that we're setting up a system to be so complex, it's almost too easy to get something wrong, even with the best of advisors and the most modern and expensive systems in place. And then that's where the class action lawyers come in, or that's where the regulatory action can come in, and the adverse publicity and shareholder activism. It's the kind of gotcha moment. Well, you didn't comply with this, and you must have known that you didn't comply, and you should have told us about this. And, class action and the like. I just wonder, is it getting too complicated? Are we expecting too much of our corporate boards?
Yeah, and I think that language that you both used of layer upon layer is right. And I think each of these individually, when either the legislation or the regulator was releasing the guide, they might have had in mind dealing with entities with significant financial and human resources to deal with things. So you look at down that list, APRA. APRA initially regulated the big banks who do have large resources and large pools of talented people to deal with things. But if you're a fintech and you're at the smaller end of the scale, you also have to deal with this with the same layer upon layer of regulation with a different resource base. So it's challenging as you go down the spectrum of corporates. The challenges can increase.
Yeah, and the interesting thing, it's really a very new development. I mean, all this stuff came in the last two decades, really, and it seems to be developing a lot of momentum, especially with all the ESG pressures coming onto boards. So let's just push on. So, you know, there has been some pushback, and I'm glad that Jason mentioned CAMAC. All the corporate lawyers in Australia regret the passing of CAMAC, which was put to the sword in 2014, probably by treasurers who are annoyed that they were getting advice to reform corporate governance, and, you know, when they didn't want to do it. But, you know, CAMAC did a major review in 2006 where they, you know, began to look at all the different personal liabilities for directors in all the different states, on different state laws and federal laws and whatever. And they put together some reforms and a model provision to provide some protection for directors. They tried to reduce the number of underlying offences from 6,700 to 2,400, halve the number of acts, which included directors' liability from 287 to 148. And there was some success. So 2006, CAMAC made these recommendations. In 2008, there was a COAG. COAG launched the Directors' Liability Reform Project, and there was some success at state and federal level. But the impetus for reform has certainly receded. And politically, you have to ask yourself, especially in light of the Hayne Royal Commission, who is going to stick their head above the trench and champion protection of directors and directors' liability in the current climate. So we seem to have, there was a bit of pushback in the mid-2000s, and that seems to have gone away.
Sorry, Matt, could I just jump in there?
Yeah.
We've just had a question from the audience. So Simon has posted up in the chat box where he says there's often a knee-jerk reaction to regulate when a gotcha moment occurs, referring back to our earlier discussion. He wonders whether there will be a swing back of the pendulum to have more regulatory consolidation and less discrete legislation, because the market will increasingly resist too much supervision. And what immediately springs to mind from Simon's comment and question there is, of course, the comments in the Hayne Royal Commission report about trying to simplify the legislation. And I think that's something that, you know, I'm concerned that we're losing so many recommendations in the Hayne report about how we can deal with very specific issues in different aspects of financial services. But those final recommendations about simplification and not overcomplicating things through a myriad of exceptions, I think is getting a little bit lost. The government, in some ways, and again, just my opinion, is very keen to be seen to be doing something and be seen to be acting on specific recommendations. But it's a much harder task to then say, well, actually, what are we trying to achieve here? Rather than reacting to a specific example, or in the case of the Royal Commission, systemic examples in particular industries. Perhaps, you know, the much more difficult task, but more important task, is saying, you know, what's a modern corporations act for the 21st century actually look like, rather than here's a problem over here, well, let's introduce some new rules and some new exceptions and some new personal liabilities and defences and whatever to deal with that, because collectively it's just a snowball effect. So I'm not sure if you have any comment on that. Are you?
No, I do. I really liked when Commissioner Haynes said, you know, we don't need to amend the law. The law is there. We just need to enforce it. And, you know, boards and regulators need to do a much better job of just following the law. So it was really, I remember reading that in the report and going, yes, that's a really fair comment. We do have a very sophisticated, deep set of principles and laws here. They're just not being enforced. So that was quite good. And it struck me that marked a bit of a high water mark, because if you hit back to, I wonder if I can find it in here, but maybe it's coming up in my slides, but I do make the point that when we did the 4th edition of the ASX corporate guidelines, there was a real debate around introducing concepts of culture and concepts of a social license to operate. And there was a real reaction from company directors and a lot of parties saying, look, we're just pushing this too far and making it very, very difficult for our boards and directors to operate. And maybe the combination of the Hayne saying, look, the law is there, let's just enforce it, and bodies pushing back against further expanding directors' duty into kind of woolly concepts of the greater good of the community, which is very difficult for us lawyers to deal with. Maybe we will head to a swing back. I'm not quite sure.
My colleague here at Sydney Law School, Dr. Kim Sheen's also just made a comment in the chat box saying one of the great challenges here with trying to simplify the range of obligations is that we're not just dealing with one regulator, as you've already mentioned, Matt. There's a variety of regulators with overlapping responsibility, and so we end up the complexity is driven in large part because it's not just corporate law that we're focused on, but as you say, it can also be APRA, it can be ACCC, it can be other regulators.
Yeah, that's absolutely true. That's absolutely true. Rob, anything from you on that?
No, I think that last one was a good point. I'm not sure when we're going to see a swing back, or if we will, but more discussion like this perhaps will help that process.
Yeah. So I just want to touch on a few recent things, and I'm going to start with the anti-slavery legislation as an example of maybe an extreme obligation that's being placed on board. So the anti-slavery legislation started in California about a decade ago, and the idea was that retailers selling clothes in California had to have a look at their procurement and where the clothes are manufactured, and do a voluntary submission on their websites as to that there was no slavery in the production of their clothes. And it was a pretty loose, pretty weak bit of legislation, and compliance has been very loose for that. So it hasn't been particularly successful. But it was picked up in the UK in 2006, which created a stronger set of legislation, which had a government-run website where companies need to load up their annual reports. And then Australia introduced legislation, I think last year or 2 years ago. So now we have, this is just an example of how a global idea can just kind of snowball. And now we have Australia, we have mandatory reporting for every single entity, not company, but every single entity with revenue of over $100 million. They need to place on a public register a total map of their procurement structure, and do a diligence of that structure and report on possible slavery and what they're doing to combat slavery and all this type of thing. And this report needs to be signed off by the board, and it's put on the public record. And I remember looking at this legislation and going, well, who can argue against slavery? It's terrible, especially in Southeast Asia. There's horrible practices going on. But why are we getting every single company in Australia or every single entity in Australia of over $100 million to go through this process, which is a very expensive and time-consuming process? And every board in Australia needs to go through this process. It just strikes me as overreach. And when this legislation came up to Parliament, there was no one really pushing back to say, look, why don't we just focus on certain industries, such as the textile industry or the seafood industry, where there are these problems? Why make everyone do it? But there was no real pushback. And before you knew it, we have this whole new body of compliance obligations that everyone in Australia has to wrap their heads around and go through the process. And it just seems very, very easy for government and politicians to layer more and more obligations on companies going forward. And I don't think it particularly solves the problem. I think a better bit of legislation would have been the government mandating certain companies and certain industries to go through this process where there's high risk, and then reserving their the ability to do that with other industries as more studies were done. But I don't know if Jason or Rob, you have any comments on that?
Yeah, I tend to share your views there, Matt, particularly when you've got, it seems there's greater risk in those industries which are importing from low-cost labour markets. That seems to me the obvious exposure areas. But if you have a company that's business is entirely bound within Australia, it's manufacturing products in Australia from resources in Australia where we have high quality labour laws and high labour rates. The labour laws should do the job of regulating the employment conditions of all employees in the supply chain, and they would in an entirely domestic scenario. And there's a lot of businesses that fall within that category. So you're right. It could have been done in a more focused way.
And now you have general counsels all across Australia going, oh, what is this piece of legislation? Having to read everything, having to get up to speed, having to hire external consultants, having to map their procurement structures, all this type of thing. Look, I don't know the numbers, but it strikes me that it's probably 10 or 15% of the economy that really has a risk here.
So we're getting a few questions coming through, which is great to see. So James has posted up and just noting that when New South Wales went through some chain of responsibility regulations in the clothing and textile industry in the mid-2000s, he recalls that there was a lot of offshoring of clothing production. So there's that problem where it's international, and then how much pressure can we put on domestic entities? And I've got colleagues at the law school who I know are looking at these sorts of issues, particularly through international institutions like the International Labour Organization. And, just again, from my own perspective, maybe this is an area where we really need to think about the relationship between legislation setting hard, bright line rules and also informal norms within industries, the role of customer advocacy, customer awareness about how certain products are made, and then trying to push companies to be a little bit more transparent. We've also had a question from Dave from State Street, who said that he's enjoying the comparative approach that we're taking in this topic. And he's asking each of you, what do you see as some future obligations which are coming over the horizon? He notes in France, there's now mandatory human rights due diligence, and there's some further rules coming in the European Union through a mix of hard and soft law. He also notes environmental and social reporting in the Corporations Act tends to be vague and doesn't adequately mirror the need for human rights and supply chain issues. He asks, what can we expect on this front in the future in Australia in terms of legislation?
Well, this is the right slide to be on, because you can see the trends coming through on this slide. So it does feel like we're heading in that direction where companies are meant to. I make the point later that we're asking our companies to enter into roles that governments used to enter into. For example, in anti-slavery, this would have been a criminal law that the government would have an anti-slavery department in the federal police looking at. And it would be the obligation of those parties to stop, the use of slavery in procurement chains. But now we're getting our companies to fulfill a role that used to be a government role. And it's just a new development. And as we saw with the money laundering, where we asked our banks to begin to police the money laundering issues, and companies just aren't particularly well suited to that role, and they don't do it well. And then before you know it, the directors are being hauled in front of a barrister and a royal commission as to why their money laundering didn't pick up, a flow of cash from the Philippines to Australia to Indonesia or whatever. And it's just this movement of obligations that used to be in the government sphere and placing them onto corporations, which is a new development. And I just don't think our companies are particularly well suited to that role.
If I can just build on that, Matt. So Dewey has posted up some comments on the chat box. And one of the points he notes is that proliferating complex rules can sometimes obscure effective regulation. So regulators having, a whole range of tools in the toolkit, lobbying government off. We only had further provisions here or stricter penalties here. Sometimes it can actually hide what's actually going on and whether the existing laws are being adequately enforced. Now, my comment to Dewey over the chat box there was, looking in my own area of corporate insolvency, we've seen this in relation to anti-phoenixing, where we've seen the government introduce a whole range of what I consider to be unnecessary and complex rules and very extensive personal liability for company directors and other officers, even though there's existing laws there that can deal with the problem. It's just that they aren't effectively enforced because there's often not a lot of money there, or there's a lack of action from the regulator and other key gatekeepers.
Yeah, it strikes me that it's very easy to introduce a new statute. It's less easy to look at the landscape and work out, where statutes and where bodies overlap, and to take the law back and to take the regulated field back to try and simplify everything. But that strikes me as that's what we need to do in this sphere. I mean, I don't think anyone is really asking why are our companies doing the role of policing, in certain spaces. We've just kind of fallen into this position through good active advocacy from various groups to say we need to do something about anti-slavery, we need to do something about money laundering, we need to do something about X. But I'm just not certain that this is the right the right way forward. And anyway, I've made that point. Let's just see if we can push on. I've got a few more bits and pieces, and we've got about 10 minutes to go. So on top of all this new regulation, we have a much more aggressive shareholder activism space at the moment, where we've got the 2 strikes rule in Australia, which interestingly hasn't been taken up anywhere else in the world. I talk about regulators looking at each other's rules, and the whole of the world has looked at our 2 strikes rule and gone, not quite fit for purpose, but it is causing boards to sit up and do more deep shareholder engagement, which is a positive. Proxy advisors, you've got large global shareholders. So Vanguard, BlackRock, and State Street make up 20% of the ASX 200. So when they sit in New York or Boston or London or Silicon Valley and they think about corporate governance, they will have a policy like an ESG policy, and they will roll it out globally. So all of a sudden, the companies in Australia have to respond to the latest trends in corporate governance in New York and London. Rob, maybe you can talk about the growth in Australian industry super funds and Westpac.
Oh, yeah. Well, what we've seen here is after compulsory superannuation was introduced a long time ago now, it's gradually built up and built up and built up. And it was really notable when Westpac had their issue a few months ago with the AUSTRAC problems. A decision was initially made by the board that, notwithstanding what had happened, that the then CEO Brian Hartzer was the right person to continue in that role, and they started out with a view to retaining their CEO. In a very short space of time, there was a series of, as I understand it, consultations between representatives of the board and the senior industry super fund investors in Melbourne who made their position very clear, and it resulted in both a change of CEO quite quickly and an agreement that the chairman would change in due course. And that was the new thing at that level in Australian corporate life, to see that backroom shareholder power changing like that. And as the superannuation funds continue to build, that's a trend that's not going to go away.
Yeah. And two other things in that space, class actions, of course, are exploding in Australia, and are not going anywhere quickly. And also, for those that haven't been outside Australia, the AFR is a really interesting, unique institution in Australia, in that there are a lot of financial centres like Hong Kong and Singapore and other places that don't have a specific financial media. I mean, London's got the FT and New York has the Wall Street Journal, but London and New York are so large that their newspapers don't operate like the gossip rag that is the AFR. So yeah, directors always say to me, how will this read in the AFR? Because we're a pretty small market in Australia, and the AFR is well resourced. So it's really sort of a public bulletin board for corporate governance and corporate issues, unlike really any other jurisdiction in the world. So that puts pressures on directors. So just to summarise my argument, that we had the traditional duties of companies to shareholders / companies as a whole, and then in an insolvency situation it swaps over to creditors. But now we have those duties, and we also have significant duties to government and regulators, industry bodies, employees, arguably environment, customers. If you think of anti-slavery, who's that duty towards? Is it the persons who create goods and supply chains? And then we're getting to a stage where you've got duties to the wider community and to sustainability and to the environment. So we're really entering into a new space for directors' duties, and there's been a significant expansion in the last sort of 15, 20, 25 years. So this leads to some unintended consequences. And the first one I'd like to raise is that we now got a disconnect between who appoints the directors. So we're still stuck in the old common law framework of directors are appointed by shareholders, very simple structure. But now we have a situation where directors owe duties to a whole range of stakeholders, the large majority of which have no role in appointing the directors. So there's a bit of a disconnect between those, and there's an accountability issue, which we seem to be solving with the sledgehammer of just more and more statute and more personal liability for directors. But that's a structural issue between the traditional common law position and where the law has developed. We've talked about the company as policeman, which is a new role for companies. D&O insurance, which is mainly a product of class action, but also other people. The average increase in Q1 2020 was 225%. I've got a friend who's the general counsel at GrainCorp, and their increase was 561% for their D&O insurance. And there's a whole series of insurers that have just left the market completely in Australia because it's just way too expensive. And now we're getting to a stage where the smaller companies on the ASX are just having to work out whether they have D&O insurance. And if you don't have D&O insurance, it's very difficult to get directors to agree to join you. So this is an unintended consequence of all the class action activity that's happening in Australia at the moment.
Maybe thinking further ahead on that, Matt, it might be a deterrent to class action cases to not have D&O insurance in place. Anyway, we'll leave that thought there.
the directors' houses in Mossman just aren't big enough. Is that your? They're only worth $4 million. We're looking for $50 million.
Exactly.
Sorry, Matt, just to build on that. So we had a question from Kath a little while ago, which dovetails nicely with what we're talking about here, where she wonders whether a simplified mandatory code of conduct could reduce regulatory burden whilst protecting stakeholders, including shareholders and consumers. And she's framed this question in the context of, we're talking about the increasing regulatory burden on directors, but she makes the point, and this is a common refrain we hear in public debates about director liability, but aren't directors generally well compensated, and therefore can't they engage professionals, including lawyers and accountants, to advise them on the range of obligations? So she's wondering, on the one hand, aren't they, or don't they have the financial resources to deal with this problem? On the other hand, could we have some kind of simplified mandatory code? If I could add a quick comment there and then throw to each of you, but I mean, if we come back to Kim's earlier question, complexity is born in part by the fact that it's not just corporate law that we're dealing with. We could introduce an expanded business judgment rule in the Corporations Act to deal with Corporations Act issues, but would that deal with ASIC Act issues? Would that deal with Competition and Consumer Act issues? Probably not. Dr. Robert Austin, a number of years ago, proposed a solution to this, which was to introduce a new provision into federal and state interpretation legislation, which would guide director liability by inserting a presumption against certain forms of liability under all legislation. So it'll be interesting to see how this debate progresses. I myself I'm sceptical that we can get one simplified answer, but I do like the idea of really going back to first principles. Like I said earlier in the discussion, what is it that we're trying to achieve here? I don't think any of us on this panel would agree that simply tacking on more and more and more liability to deal with yesterday's problem that we read about in the paper is the right way to go.
Yeah, well, on that financial point, people say, oh, these companies have got resources to do this. Well, yes, companies might spend $5 million or whatever on compliance, and maybe it should be 10 or 15 or $20 million, but that just takes away from wages, it takes away from superannuation, it just takes away from a whole bunch of things. And I just think we just need to balance those two going forward, and especially as super takes up more and more of company ownership in Australia. Those costs are borne by mum and dad in the suburbs who are getting less dividends from these companies in a way. But I'm just not certain that more regulatory and more complexity is producing better results. Don't know, but that's a huge issue. And just I'm cognizant of the time. I just wanted to leave with my big quote, which is, "The road to hell is paved with good intentions." But basically, I just want to make the point that it feels like compliance burdens are overwhelming our companies, and we have to begin to think about some solutions. Some people say we should be delegating more to subcommittees, but then with more delegation, who is liable? ASIC has made the point that boards can't delegate to subcommittees and avoid responsibility. There's a big question of why a company is such a soft target. Whenever there's an issue, it seems to be, we'll just make the company do it and we'll just get more and more compliance. I think we're going to reach a stage very soon where we need to choose between our current sort of part-time board structure with less compliance burdens, or we move to a full-time board with current and increasing burdens. And by part-time, full-time, the typical company director in Australia is on 2 or 3 boards. They spend kind of, maybe a week in a month looking at a company. There's an argument to be made that a director of Westpac, that's a full-time job. You should be doing that all day, every day. And we might head down that path. The other option is the dual board model. But I think where we are at the moment is we're in this unsustainable space where we have part-time boards who are dealing with this massive compliance burden. And and they're not thinking about strategy, and then they're not thinking about the long-term issues for the business. They're just trying to tick the boxes to get through their meetings so they can fulfill all their compliance obligations.
And then on top of all of that, we throw the pandemic.
Well, no, and this is the point with the anti-slavery legislation. It was coming in, and I actually wrote a letter to the minister saying, look, can we think, all the boards I'm dealing with are struggling with, how to pay their employees, how to pay their rent, all these massive issues. Should they then have on their board meeting introducing all this new anti-slavery legislation compliance issues? I mean, they're just trying to survive and do the basics. Is there any way? And the government, I think, has delayed the introduction of anti-slavery from, by 6 months. But I think there's an argument for possibly a year or two, while we just try and survive as an economy, and these companies try and survive and stay away from the quarter-mentors of this world.
As nice as they are.
As nice as they are. So Jason, that's the hour. I'm happy to take questions and for as long as people would like, but I'll hand it back to the chair.
Thank you. So I've got a colleague who's made a comment here, Dr. Fadi Ayoun, who makes the point, who would want to be a company director, especially in this era? There's often the assumption, that they're paid lots of money, and some of them are. But as you note, Matt, the capacity, just the time commitment that you need these days, it's very difficult to be an independent non-executive director of more than one or two companies. And of course, drawing back on your earlier discussion about rising institutional investor activism, we're seeing the proxy advisors going after directors who have more than 2 or 3 ASX 200 positions. So that certainly seems to be more difficult. I would tend to agree with Fadi's comment there. Who would want to be a director in this environment? There's so much uncertainty. We've got the temporary suspension and modification of certain laws, but I think we do need to be starting to ask the question: do we need some further amendment post end of September when some of these temporary measures end?
Well, just to give you a story from the front line on that, I was involved in a company that was, it was heading into receivership. It had an ASIC investigation into it. There are only 3 directors left on the board, and one of the directors left. It was a public company. And because they were in this distress situation, they couldn't renew their directors and, their D&O insurance. And they needed some more directors because they're actually heading into a quorum issue. They didn't have enough directors to hold a board meeting, and they couldn't find anyone. No one wanted to get onto this board. The risks were just enormous, and it was just a real headache. And I think we're gonna have this more and more going forward. I think it's different when you've got a successful company moving forward, but in a stress situation, it's who would want to join a board? And I often give advice to friends quietly, saying, look, I know you want to be a director, but maybe this isn't a board you want to join, because you're looking at class actions, you're looking at potentially regulatory investigations. Do you want to put yourself in that position? I'm sure, Rob, you've got stories like that as well.
Yes, many. But I think Jason raises a good point as to what happens as the temporary laws either revert to normal or roll into something new, because we've certainly seen lots of things happen in commerce as a result of those changes, and it's almost certainly well the changes happen because the changes in commerce have happened because of the law changes. So come September, is it going to be a hard stop? Is it going to be a continuation of the same, or is there going to be some roll off in the rules? Do you have any insight, Jason? Any ideas about how it might unfold?
Well, I know the government is actively consulting with industry groups and professional associations on what temporary changes perhaps should be extended, and in what form. So I've been participating in some law reform discussions with some different groups. So I know they are at least thinking about that, which is a great thing to see, and consulting broadly on that issue. I mean, from my own perspective, in terms of corporate insolvency, the kind of hard cliff that's coming at the end of September, we could see very significant increases in corporate failures and personal bankruptcies. And that's something that we need to manage, even at the really infrastructure level, in terms of, do we have enough liquidators and bankruptcy trustees to actually deal with the problem, for counselling on the regulatory side as well, in addition to some of the more flexibility amendments that we've seen in the general corporate space. But everyone's dealing with this at the moment. So if we go back to our earlier point about, we're not in this alone, and that's the slogan, we're all in this together, sort of thing. Looking at what's happening in other jurisdictions, looking at some of the reforms that are coming through, what's working, what isn't, if we continue these sorts of dialogues. But my main point is to not lose sight of the wood for the trees, that we might debate a particular amendment, but let's not lose sight of the broader question of how the Corporations Act works, and this collective snowballing complexity that we're seeing in director liability. And I think that is a problem at some point we will need to face up to, and that's going to need something like a CAMAC or Australian Law Reform Commission, where we can go out and do what England's done, do what Singapore's done, do what Hong Kong, South Africa's done, and actually do a wholesale reform. Because a lot of the provisions that we've got here have just been tacked on over the years, and a lot of the provisions have been in the legislation for 150 years, and we should be asking the question, what's working, what isn't? There's a lot of models we could follow. Gentlemen, I think we should draw it to a close there. We've just ticked over the hour, so I'm mindful of everyone's time. Really appreciate you giving up your time to come along and talk with us tonight about these issues. We've had a lot of great comments on the chat box there, so I think everyone's gotten something out of this. We've covered a huge amount of territory, as we always were going to do. Just again, a couple of housekeeping points. So the slides will be made available for people who've registered for the webinar, so we'll be sending that out in the next couple of days. This has also been videoed, and the video of this will be put on both the Gadens website and also on the Sydney Law School YouTube page. If you're interested in these webinars, particularly around corporate and business law, you can go to the Sydney Law School events page. We do have a couple of webinars coming up over the next few weeks. On the 14th of July, we've got a webinar with a UK academic and another academic from here in Sydney, talking about pre-pack sales in corporate debt restructuring. So that should be interesting, because there's been some interesting developments in England on that. And then on the 22nd of July, we'll be discussing corporate social responsibility, looking in particular at Taiwan and China, and then comparing it with what's been happening in Australia. And then on the 29th of July, we're actually going to be talking about continuous disclosure and reforming continuous disclosure rules with my colleague, Dr. Kim Sheehan. So thanks, gentlemen. Really appreciate your time. And thanks everyone who's attended tonight for giving up your time. We had a fantastic turnout and some great questions. Thanks very much.